It's 11:47 p.m. You're in bed, phone charging on the nightstand, when you hear it. Not your phone, someone else's, knocking, hard. Then footsteps outside your door, and a voice says, "Police department, open up." Your heart stops. You didn't call anyone, nothing's wrong. But somewhere, somehow, a 911 call was made, and now there are officers standing on your porch at midnight, and you have about 10 seconds to decide what happens next. Here's the question that terrifies almost everyone the first time they think about it. Can they just walk in? Does a 911 call, even one you didn't make, even one that might be a mistake, a prank, or a neighbor who misheard something through the wall, give police the legal right to open your door and step inside your home? The answer is not what most people assume. And honestly, it's more complicated and more interesting than a simple yes or no. Because here's the twist nobody tells you. The Fourth Amendment to the United States Constitution was written specifically to prevent government agents from barging into private homes without justification. It protects what the founders called the right of the people to be secure in their houses against unreasonable searches and seizures. For over 2 centuries, courts have treated the home as the single most protected space in American law. The Supreme Court has said, flatly, that at the very core of the Fourth Amendment stands the right of a person to retreat into his own home and there be free from unreasonable government intrusion. That's not a suggestion. That's the foundation. So if that's true, why do so many people believe a single phone call can override all of it? Let's rewind for a second, because to understand what happens at your front door, you need to understand what happened in a courtroom decades before you were born. In 1980, the Supreme Court decided a case called Payton versus New York. Police had probable cause to believe a man named Theodore Payton had committed murder. Instead of getting a warrant, they went straight to his apartment and forced their way in. The court ruled that was unconstitutional. Even with strong evidence of guilt, officers generally cannot cross the threshold of a home to make an arrest without a warrant, absent an emergency. That ruling became one of the pillars of American privacy law. Your home is not just another location. It's a fortress in the eyes of the law. But here's where it gets complicated and where that midnight knock starts to make sense. There's an exception, a narrow one, but a powerful one. It's called the Exigent Circumstances Doctrine, and it exists for exactly the kind of moment you might be imagining right now: someone screaming, glass breaking, a child crying out for help. The idea is simple. If police reasonably believe that someone inside a home is in immediate danger, they don't have to stand outside filling out paperwork while that danger continues. They can enter without a warrant. That single exception is the reason a 911 call can trigger a legal entry. Not because someone dialed 3 numbers, because of what that call reasonably suggests is happening behind your door. In 2006, the Supreme Court examined this directly in a case called Brigham City versus Stuart. Officers responded to a loud party complaint late at night. When they got there, they saw through a window that a fight was in progress inside the house. Adults restraining a juvenile who was throwing punches. The officers entered without a warrant. The Supreme Court upheld that entry, reasoning that police may enter a home without a warrant when they have an objectively reasonable basis to believe an occupant is seriously injured or imminently threatened with injury. Notice that phrase. Objectively reasonable, not a hunch, not a guess, not just any call to a dispatcher. The situation has to genuinely appear urgent from the perspective of a reasonable officer standing at that door. So now picture your situation again. Someone called 911, maybe reporting a domestic disturbance, maybe reporting screaming, maybe reporting something they thought they heard through a shared wall. The officers arrive. What happens next legally depends almost entirely on what they observe and what they're told once they get there, not simply on the fact that a call was placed. This is where most people get the law completely backwards. A 911 call, by itself, is not a warrant. It's not permission. It's information. It's the starting point of an investigation, not the finish line of one. Think about it from the officer's perspective for a moment, because this matters more than people realize. When police respond to a 911 call, especially one involving reports of violence or a person in danger, they're walking into total uncertainty. They don't know if the caller was accurate. They don't know if it's a mistake. They don't know if it's a hoax. Studies on emergency dispatch and swatting incidents, a term for false emergency calls made to provoke a heavy police response, have shown how dangerous and disruptive fake or mistaken reports can become. So the officers have to assess the situation in real time, at your door, often within seconds. And that assessment is exactly what determines whether they can enter without your permission. If, when they arrive, everything appears calm, no yelling, no visible injury, no sounds of distress, and you answer the door and indicate everything is fine, officers generally do not have automatic authority to force their way inside. They may ask to come in and look around. They may ask you questions, but asking is different from demanding. And this is the part almost nobody explains clearly enough. You are not required to consent to a search of your home simply because officers are standing there. Consent must be voluntary. If you say no, and there is no separate legal basis, such as a warrant or a genuine emergency, they can observe or reasonably infer. They cannot force entry based on refusal alone. But here's the twist that changes everything, and it's the part that creates real tension in these encounters. If officers hear something alarming through the door, someone yelling for help, sounds consistent with a struggle, a child crying out that sounds distressed, that changes the legal calculation immediately. At that point, courts have consistently held that officers may enter to check on the safety of anyone who might be inside, even over your objection, even without a warrant, because the law prioritizes preventing serious harm over waiting for judicial paperwork. This is sometimes called the emergency aid exception, and the Supreme Court reaffirmed and clarified it again in a case called Michigan versus Fisher in 2009. Police were called to a chaotic scene, a house with a smashed truck in the driveway, broken windows, and blood on the hood. When officers looked inside and saw a man who appeared angry and injured, they entered. The Supreme Court upheld that entry, stating that officers do not need ironclad proof of a likely serious injury to enter a home. A reasonable basis to believe someone inside needs immediate aid is enough. So we now have two very different scenarios living inside the same doorway. One, where a 911 call turns out to be unfounded and there's no visible or audible emergency, in which case your right to refuse entry generally stands. And two, where officers have genuine, observable indicators that someone is in danger, in which case that right can be legally overridden in the name of protecting life. This is exactly why the same set of facts, a stranger calling 911 about your house, can end in two completely different outcomes, depending on split-second details you might not even be aware of. Background noise, tone of voice, what's visible through a window, what they hear the moment your door creaks open. Now here's a twist that catches almost everyone off guard, especially in situations involving shared living spaces. What if you live with a partner, a roommate, or a family member, and that person is the one who invites police inside while you are the one saying no? In 2006, the Supreme Court addressed this exact scenario in Georgia versus Randolph. A husband refused to let officers search his home, but his wife, who lived there too, gave consent. The Supreme Court ruled that when one resident is physically present and objecting, police generally cannot rely on another resident's consent to search shared areas. Your explicit refusal, standing right there, carries real legal weight, even if someone else living with you says otherwise. But notice the specific wording there: physically present. If you're not there, if you're at work, asleep in another room they don't know about, or simply not standing at the door when the other resident says yes, the legal picture can shift again. This is why these situations are almost never simple yes or no answers. They depend on exact facts, exact timing, and exact circumstances, which is exactly why courts write such lengthy opinions trying to draw these lines. So let's bring this back to that midnight knock, because by now you might be wondering what you're actually supposed to do when it happens to you. First, stay calm. Officers responding to a possible emergency are, understandably, on high alert, and how you present yourself in those first few seconds matters. You are not required to open the door to speak with police, though many people choose to, if only to resolve the situation quickly. If you do open it, you can ask what the call was about. You can calmly state that everything is fine inside. And critically, you can clearly and respectfully decline consent to a search if there is no visible emergency. Something like, "Officer, I understand you're responding to a call, but I'm not comfortable with a search, and I do not consent to you entering my home." That single sentence matters more than people realize. It doesn't guarantee they won't enter. If they believe there's an emergency, they still can, but it preserves your legal position and can matter significantly later if the encounter is ever reviewed in court. What you should never do is physically block a doorway, raise your hands aggressively, or try to argue extensively in the moment. Legal challenges to whether an entry was justified happen afterward in courtrooms with lawyers, evidence, and time to think. They don't happen productively in the 15 seconds you're standing in your doorway at midnight. Comply with lawful orders, stay respectful, and remember that verbally asserting your rights is completely different from physically resisting. And here's something that surprises a lot of people. Laws and specific procedures can vary somewhat by state, particularly around domestic violence calls, welfare checks, and how quickly officers are trained to treat certain 911 reports as emergencies. Some states have specific statutes governing mandatory response protocols for domestic disturbance calls that can affect how quickly officers decide an entry is justified. So while the constitutional framework we've covered applies nationwide, the exact way it plays out on your specific porch, in your specific city, can shift slightly depending on local law and departmental policy. Which brings us to the single biggest insight in this entire story, the one thing that ties everything together. A 911 call does not open your door. Your circumstances do. The law isn't triggered by the phone call itself. It's triggered by what a reasonable officer perceives once they arrive, weighed against more than 200 years of constitutional protection, built specifically to keep government agents out of private homes without genuine justification. That's the balance the law is constantly trying to strike, protecting you from unnecessary intrusion while still allowing for the possibility that somewhere behind a closed door, someone might actually need help. It's not a perfect system, but it's a deliberate one, shaped case by case, courtroom by courtroom, over generations. So the next time you hear a knock you didn't expect, you'll know it's not about the call that was made. It's about what happens the moment that door opens, and knowing your rights in that exact moment can make all the difference. If this raised more questions for you about what police can and can't do during a traffic stop, especially around searching your phone, you're going to want to watch the video I've got linked right after this one. It picks up exactly where this conversation leaves off, and it might change the way you think about your next encounter with law enforcement.